Good morning, this is Melanie Daly here with the Daly Grind, and we're having a morning cup of coffee to discuss another workers' compensation issue. Today we are going to talk about independent medical examinations and whether it is necessary in a certain case depending on the posture of the claim. A lot of our clients are very quick to schedule I.M.Es when we wouldn't necessarily recommend one. For instance, in the beginning of a claim, especially for an occupational disease, where the claimant has the burden of establishing a link between his job duties and the alleged injury, sometimes we might not recommend an I.M.E. because that essentially could give the claimant another bite at the apple to give another doctor the history of his work and additional duties that he has. Because essentially when we're deposing the treating provider on an occupational disease claim, we want to pick their brains on what they know about what the claimant does. If they don't know a lot about the claimant's job duties, then the claimant essentially is going to have a hard time proving that it was actually an occupational disease related to the duties of his work. There is a third department case that indicates when a doctor does not know the specifics of the claimant's job duties, then the claimant will not meet the burden to establish that claim. So therefore, sometimes we do recommend holding off on an I.M.E. in those instances, because that essentially, if he didn't give enough detail to his doctor to find causal relationship, he surely might snap out of it and then go to the I.M.E. and give them a whole bunch of additional details that he didn't previously disclose, and then the I.M.E. would find causal relationship. Then it's kind of an uphill battle for us to try to defend the claim, because the claimant got another chance to explain his job duties. So that's one instance. Another instance would be possibly if the claimant has returned to work full duty, full wages, and we're up on permanency. A lot of times if there's no running awards, there's really no rush on our end to get the I.M.E. on permanency. So we like to recommend that our clients wait to see what opinion is produced by the claimant for that loss of years. In that way, we can actually compare the treating provider's C4.3 with the remainder of the file, the history of the medical treatment, the claimant's range of motion upon exam, and all the prior appointments. We can compare them to the guidelines, and we can say, he's not that far off. You don't need an I.M.E. because that's essentially, again, possibly going to give the claimant another bite of the apple, especially those claimants who tend to exhibit signs of symptom magnification. We don't want to give them another chance to essentially show a more severe range of motion to that I.M.E. So essentially in that case, we just say, hold off. There's no awards ongoing, and wait to see what the claimant comes up with. In those cases, we could either probably, in some cases, not probably, possibly, I should say, either discredit that opinion based on the guidelines alone and case law, or we can say, you might want to just accept this opinion, or we'll say, we'll get you an I.M.E. because that way you can defend the claim. But there are more instances. We are keeping this short, so we don't want to go to much detail. But if you ever have any question before you schedule an I.M.E., reach out to one of us and determine whether you really need one, because sometimes you don't. And as we know, I.M.Es can be costly. They can be a detriment to the claim, and a lot of times we like to really try to defend the claim without an I.M.E. So thank you for joining us. Hope you're enjoying your morning coffee, and we hope you have a great week, and we will see you next time. Thank you.